Hello and welcome to Litigation Matters, Episode 1. My name is Stuart Clubb and I'm a partner and solicitor advocate here at Shoesmiths, and I jointly head our Scottish Litigation Services team. Litigation Matters is a new update series in which we take a look at developments in the world of litigation in Scotland, whether that be new case law, new legislation, changes in rules and procedure, or anything else that may be of interest to clients, in-house lawyers, or anyone else operating in the area of commercial dispute resolution here in Scotland. And each episode will have a different focus depending on what's making the legal headlines at the time of recording. So there may be an insolvency focus to one episode, or a commercial or property litigation focus to another, really just depending on the case law that's been issued or any particular hot topics or trends we're seeing at the time. And obviously at the moment there is one topic which continues to dominate not just litigation, but the entire legal landscape and beyond, and that is of course the Covid-19 pandemic. So for this inaugural episode of Litigation Matters, I wanted to take a look at the continued impact of the pandemic on the civil courts and where things currently stand in terms of raising and progressing actions here in Scotland. As most of you will know, the Scottish Court Service were initially fairly slow to adapt to the crisis, with their initial response being to curtail and put on hold everything but urgent or essential civil court business, such as interim interdict applications or imminent time bar cases. My colleague Aileen McGowan, an associate in our team, wrote about the effect of this in more detail in her recent article in Scottish Legal News on the need for a digitalised civil court system, but essentially what this meant was that for the vast majority of civil business in Scotland, the court system simply ground to a halt. However, over the last couple of weeks, we've seen a number of positive developments in terms of getting civil justice back up and running beyond only urgent or essential business, including the very first virtual court hearing in Scottish legal history taking place in an inner house appeal over WebEx video conferencing. So where, as I sit here on the afternoon of Monday 11th of May, do things currently stand in terms of civil business here in Scotland, and are we any closer to things getting back to business as usual? Well, in order to answer that, we need to look at the Court of Session and the Sheriff Court separately, and we'll start with the Court of Session. In summary, the Court of Session is continuing to sit with priority being given, understandably, to urgent or essential civil business. As I mentioned earlier, it was in the inner house of the Court of Session that the first virtual hearing took place a couple of weeks ago, and going forward the inner house will sit as an online court for civil appeal hearings. In the outer house, procedural business is being conducted by telephone hearing or written submission, and that applies to ordinary, commercial and petition business, although it's understood that virtual hearings will also be extended to the outer house very soon. Documents required to be provided in electronic format, and where documents required to be signed, electronic signatures will be accepted in accordance with Schedule 4 of the Coronavirus Scotland Act 2020. And I have to say that so far I've found the Court of Session to be very efficient at dealing with the submission of electronic documents. Last week I submitted the documentation for an out-of-court administration appointment, and it was processed and turned around by the petition department relatively quickly, with them returning the stamped and timed appointment documentation to me by email within, I think it was about an hour and 20 minutes from me sending it in. And I do hope that these measures become the new normal and that we don't revert back to the archaic, and as this crisis is proving, somewhat unnecessary over-reliance on paper. In terms of hearings where witnesses are required, these are continuing to be adjourned, and we await further guidance from the court as to when and indeed how such hearings will recommence. It's also worth mentioning that the current Court of Session guidance was stated to cease to have effect from yesterday, the 10th of May, unless extended, but the Scottish Court Service have confirmed that updated guidance is being drafted and should be issued at some point later today. So that's a brief overview of where things currently stand with business in the Court of Session, but what about the Sheriff Courts, which is where the vast majority of civil actions in Scotland are raised? It's fair to say that the Sheriff Courts are less advanced than the Court of Session in terms of facilitating the progression of civil actions, even procedurally. While we've seen that most procedural business will now progress in the Court of Session as a matter of course, that's not the case in the Sheriff Courts. Up until the 1st of May, the Sheriff Courts were still only dealing with urgent or necessary business. Again, the types of cases which fell into those categories included interim interdicts, time bar cases, and urgent corporate insolvency and sequestration applications. All other cases were put on hold. However, from 1st May, new guidance came into effect in respect of progressing certain categories of civil business in the Sheriff Courts. In effect, what this guidance means is that if your action falls within one of the permitted categories of case, including ordinary and commercial actions, as well as corporate insolvency proceedings, and your action was on hold, whether adjourned or sisted, then you can apply to the Sheriff to have your action restarted. Crucially, however, the sheriff will have to be satisfied that there is a good reason why the action should be restarted and that the action can be progressed remotely without recourse to a hearing which requires a leading of evidence. The procedure for making a restart application is, I think it's fair to say, fairly prescriptive. There's a pre-application requirement to explore with the other parties to the case what their position is on restarting the action. There's a prescribed form and prescribed information and documentation which must accompany the application, and there are time limits which must also be observed. And I think that the key to whether this first step in getting non-urgent civil business back up and running in the sheriff courts is a success or not will be the approach of the sheriffs in assessing what amounts to a good reason for having an action restarted. In theory, though, swift justice in our court system should really be a good enough reason in itself. Now, the guidance stresses that this is not a return to business as usual, and the Scottish Courts and Tribunals Service have stated that the purpose of these restart arrangements is to get cases progressing with a view to getting them closer to conclusion or resolution during this lockdown period. Again, in theory though, a rationale which would be applicable to all cases which are currently on hold. It is of course early days and we'll have to wait to see how successful these restart arrangements are in practice, but it's certainly a promising first step in the right direction, albeit one which falls short of the Court of Session's approach of automatically allowing procedural hearings to proceed as scheduled. That said, it was just announced yesterday that the first virtual Sheriff Court civil hearing will take place at Inverness Sheriff Court tomorrow, which is another positive development. So that's a relatively brief overview of where things currently stand in terms of raising and progressing actions here in Scotland. It's certainly a much improved situation from where things were at a few weeks ago, but there's still a long way to go before we're back to anything like business as usual. However, as I mentioned, I hope that certain of the new measures introduced, such as the use of electronic submission of documents and digital signatures, continue beyond the current crisis. Now, it should go without saying that the guidance I've summarised there has been kept under regular review and may even have changed by the time you watch this video. So please do regularly check the Scottish Courts website and their Twitter feeds for the most up-to-date guidance. And of course, for more detailed advice, then please don't hesitate to get in touch with either myself or your usual contact within our litigation services team here in Scotland. And that brings me to the end of the first episode of Litigation Matters. I hope you found that to be informative. Take care and thank you for watching.